As we frantically race into the third millennium, with microprocessors becoming faster, cheaper, and smaller, with surveillance cameras proliferating in public spaces, with the Human Genome Project about to issue its first working draft of the human DNA sequence, and with an out-of-control Frankensteinian machine named the War on Drugs, all awhirl in the ocean of modern-day culture, it is imperative that we as a society expressly acknowledge the fundamental human right to cognitive liberty and immediately begin to define its contours. Encroachments on cognitive liberty can take various forms. New technologies such as biogenetic modification, human-computer interfacing, brain scanning, nanotechnology, neural networking, so-called neurotherapy, and new pharmaceuticals all raise exciting possibilities for human evolution. But, if not developed and used responsibly, they and the legislation they spawn could pose new threats to cognitive freedom. The trend of technology is to overcome the limitations of the human body, and the web has been characterized as a virtual collective consciousness and unconsciousness. What are the implications for mental autonomy when wearable computers become wet-wired to our own minds, and memory is augmented by a high-speed wireless connection to the web? Similarly, advances in biotechnology and drug design increasingly raise legal and ethical questions related to cognitive liberty, including what rights people will have to access these and other technologies, and what rights will we have to avoid them. Calibrating cognitive liberty. Part of elucidating a theory of cognitive liberty is simply recognizing when free cognition is being infringed. Restrictions on physical liberty, for all their pain and terror, at least have the benefit of being relatively easy to recognize and call attention to. During World War II, the Nazi concentration camps for Jews and the American internment camps for Japanese Americans were marked by the machinery of physical control: fences, barbed wire, and guard towers. Similarly, from 1961 to 1989, a concrete and barbed wire wall, overseen by 116 guard towers, divided the city of Berlin. Anyone who tried to cross that wall without a special authorization risked a bullet in the back of his or her skull. In contrast to the usual visibility of government restraints on physical liberty, restraints on cognitive liberty are most often difficult to recognize, if not invisible. Consciousness is so complex and multifaceted that it may never be understood. Unfortunately, the inability to understand consciousness does not equate to an inability for others to control it. How then can we recognize nefarious attempts to control consciousness? In one respect, absolute control of one's own consciousness is an impossibility. While each of us carries our own brain in our own skull, the process of consciousness itself is interactive. All of our senses continuously feed data into our brains, producing a dance of cognition that perpetually swirls the exterior world with the interior world, creating a seamless, edgeless, aperceptive feedback loop. Our minds are continually changing, continually interfacing with the other. Cognitive liberty clearly cannot mean cognitive isolation. Mind control, like most everything else, comes in degrees. A discussion with a friend may make you change your opinion on a topic. It may even change your life. But does that amount to mind control? Was your cognitive liberty violated? Over $200 billion is spent each year by companies unabashedly striving to manipulate our desires, to literally make us want their product. If you see an advertisement, or many of them, for a product, and that advertisement, replete with imagery of the good life, causes you to purchase the product, have you been the victim of mind control? Has your cognitive liberty been violated? What if the advertisement is embedded with auditory or visual subliminal messages? What if the advertisement is embedded in primetime television programs, passing as program content rather than demarked as a commercial? Or suppose you are a 12-year-old placed on Prozac or Ritalin, largely because your school teacher has quote-unquote diagnosed you as depressed or suffering from attention deficit disorder. Has your cognitive liberty been violated? The answers to the above questions depend upon how finely one calibrates cognitive liberty. But some scenarios, some infringements on mental autonomy are crystal clear and ought to present limit cases where general policies and specific rules emerge in high-definition clarity. Yet even in so-called limit cases, the U.S. government, including its legal system, has often acted inconsistently. A very brief history of U.S. government mind control. In 1969, U.S. Supreme Court Justice Thurgood Marshall wrote, without mincing words, quote, "Our whole constitutional heritage rebels at the thought of giving government the power to control men's minds," close quote. Yet contrary to Justice Marshall's strong pronouncement, the U.S. government has not consistently respected or protected cognitive liberty. Indeed, some of the government's offenses seem to come directly from the pages of a dystopian novel, like George Orwell's 1984. Imagine, for example, if the U.S. government passed a law mandating that all citizens receive monthly injections of time-release sedatives, justifying the law on the public health grounds that sedated people are more productive at routine, repetitive tasks, are less violent, and are less of a drain on public resources. What if those who did not voluntarily report at the time and place appointed for their injection were rounded up by the police and forcibly lobotomized? Would anyone doubt that such a law infringed not just on one's physical freedom, but also on one's cognitive freedom? It is not exactly an unthinkable scenario. From the 1920s through 1970, pursuant to the laws of at least 32 states, more than 60,000 people were deemed eugenically unfit. Many of these people were involuntarily sterilized, in part because of low scores on intelligence tests. When one of these laws was challenged and the case reached the United States Supreme Court, it was upheld, with Justice Oliver Wendell Holmes smugly proclaiming, quote, "3 generations of imbeciles are enough," close quote. Until 1973, homosexuality was listed as a psychiatric disorder in the Diagnostic and Statistical Manual of Mental Disorders, the DSM. People who admitted being homosexual, or who were accused of being gay or lesbian, were subject to involuntary confinement under mental health laws and subjected to reparative therapy or conversion therapy, designed to convert them into heterosexuals. Treatment, in addition to counseling, included electronic shock triggered by penile erection, drugging, and hypnosis. Even though homosexuality was deleted from the DSM in 1973, it was not until December 1998 that the American Psychiatric Association finally disapproved of reparative or conversion therapy. Alan Turing, one of the founding fathers of artificial intelligence theory, was arrested for a violation of British homosexuality statutes in 1952 after he admitted having a homosexual affair. Believing that his sexual orientation was a personal matter, neither a sin nor a crime, he presented no evidence at his trial, which occurred on March 31, 1952. In lieu of prison, he was ordered to submit to estrogen injections for a year. Following a period of depression, likely the result of the injections, he committed suicide on June 7, 1954. In the 1950s, 60s, and early 70s, the U.S. government illegally and unethically drugged unwitting U.S. citizens with psychoactive substances, including LSD, as part of projects Bluebird, Artichoke, and MK Ultra, all in an attempt to develop techniques of mind control. Richard Helms, a chief planner of MK Ultra, wrote in a planning memorandum that the program was designed to, in part, quote, "investigate the development of chemical material which causes a reversible, non-toxic, aberrant mental state the specific nature of which can be reasonably well predicted for each individual. This material could potentially aid in discrediting individuals, eliciting information, and implanting suggestions and other forms of mental control." Close quote. While the MKUltra program began with tests in the laboratory on willing volunteers, the CIA quickly saw the need to expand the testing to determine what the effects of drugs such as LSD would be on unsuspecting people. Thus, in 1953, the CIA moved its mind control program into the streets of America and began the covert testing of materials on unwitting U.S. citizens. In subsequent installments of this essay, we will see how the U.S. government continues to promulgate certain policies that, while cloaked in public health or public safety justifications, amount to an impermissible government action aimed at policing thought and interfering with the mental processes of citizens. Freedom's invisible landscape. The right to control one's own consciousness is the quintessence of freedom. If freedom is to mean anything, it must mean that each person has an inviolable right to think for him or herself. It must mean, at a minimum, that each person is free to direct one's own consciousness, one's own underlying mental processes, and one's beliefs, opinions, and worldview. This is self-evident and axiomatic. In assessing what rights are fundamental, and thus entitled to the most stringent legal protection, the U.S. Supreme Court has stated that fundamental liberties are those, quote, implicit in the concept of ordered liberty, close quote, such that, quote, neither liberty nor justice could exist if they were sacrificed, close quote. Under another test, fundamental liberties were characterized by the court as those liberties that are, quote, deeply rooted in this nation's history and tradition, close quote. Over 70 years ago, Justice Brandeis acknowledged in a landmark privacy case that cognitive freedom was one of the principal protections designed into the Constitution. Quote, "The makers of our Constitution undertook to secure conditions favorable to the pursuit of happiness. They recognized the significance of man's spiritual nature, of his feelings, and of his intellect. They knew that only a part of the pain, pleasure, and satisfactions of life are to be found in material things. They sought to protect Americans in their beliefs, their thoughts, their emotions, and their sensations. They conferred, as against the government, the right to be let alone, the most comprehensive of rights and the most valued by civilized man." Close quote. But, while certain justices have at times pointedly acknowledged the fundamental nature of cognitive freedom and the nefarious nature of government interference with the intellect, this important freedom remains only obliquely defined within the U.S. legal system. Ironically, the lack of a comprehensive treatment may be because cognitive freedom is so self-evidently a basic human right. Whatever the reason, without a coherent cognitive liberty jurisprudence, present and future infringements on cognitive liberty risk passing unnoticed or unremedied. In the next installment of this essay, we will begin to dig deep into privacy, due process, and the First Amendment cases, in an attempt to excavate a theoretical scaffolding for cognitive liberty. As I believe the cases will show, cognitive liberty is the invisible landscape from which springs some of our most cherished and protected freedoms.